Hello, everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So, today we will be discussing three articles. The first article is from The Hindu, which is titled as The Absurdity of Anti-Defection Law. Basically, this article talks about that why the anti-defection law has not been really fruitful, and the very purpose for which it was brought in has not been sufficed or has not been fulfilled by it. And the second article is again from The Hindu, which is titled as Inhibiting Free Speech. So this article talks about the parliamentary privileges as well as the power of the legislatures to, the quasi-judicial power also that they have in hand. So what are the prospects of that has been discussed in this article. And thirdly, we have this article inside New Social Media Code from the Indian Express. Basically, there were a lot of articles today that were discussing about the new regulations and rules that have been brought by the government in order to control the OTTs which are over the platform, the like Netflix, Amazon Prime, etc. All these platforms. So the rules that have been brought in this direction have been discussed in this article. And fourthly, we have the news in flash column. So this if you're preparing for judicial services examination, you can have a look at the Lord of the Courses, which is the judiciary test prep course from LawSikho. The link to this course is available in the description box below, and also you can download free study material for your own help and preparation. Also, another announcement that we have been making since now, it is a humble request that all of us, all the viewers who are there, who are specifically here for the news analysis and the current affairs update, please subscribe to our other channel, which is the Clat Prep channel. The link to this channel is there in the description box below. Since we will be diverting all this content very shortly over there, even now also you can view all of this content on the other sister channel of LawSikho. So please subscribe yourself to that channel so that you don't miss any update that is coming up in the coming days. Further, we have the Clat course as well. So if you're looking forward for cracking Clat 2021 as well, you can definitely look at this course. The link to this course is also there in the description box below. And also we have the latest edition, which is the limited insolvency examination by IBBI. You can have a look at this course too. So this is the multiple choice question from yesterday's discussion. Which section of the Indian Penal Code defines criminal conspiracy? Your options are Section 124A, Section 120A, Section 141, or Section 239. This is the descriptive question from today's discussion. What do you understand by anti-defection law? What changes are needed in it for better and effective implementation? So this is the very article that has been there in the Hindu today, which talks about the absurdity of the anti-defection law. So it says that here we will be discussing it into detail, but let's just break it down from this very discussion. So wherein the first thing that it says is that this anti-defection law, which is in the 10th schedule, so specifically the 10th schedule was brought in the constitution in 1985 to combat the evil of political defections. So basically what was happening was that the MLAs and MPs, they were not sticking back to their parties, and due to which a lot of instability was seen in the government. Then further, this article moves on and tells us about the range of this very provision of anti-defection law, that it is not only applicable on the money bills or the confidence motions, rather it is applicable to all kinds of votes that take place in a house, on every bill and every other issue. Then further, this article moves forward to tell us about a broken chain in India as to why, in the very first instance, the constitution framers of the Indian constitution, by bringing in the parliamentary form of government, we wanted to have a government which is more accountable. So for us, accountability was even more important than the stability, which is far more ensured in the presidential form of government. But still, this chain breaks down in India that because this chain of accountability is not able to take place in the country, because even after having the anti-defection law, this particular problem still persists. Further, it talks about eroding the legislatures. Now, by eroding the legislature, it says that it is an important consequence of an anti-defection law is that it is hollowing our legislatures. Now, what happens is that the only purpose of the legislators is not to just stick by the party, but also to make sure that they can put in their inputs while a law is being framed. But in this scenario, if at all they move against their party, this anti-defection law comes as a barrier in this intellect of these political leaders, and thus the core role of an MP, that is a member of the parliament, to examine and decide on the policy, which is the very purpose of these MPs. Bills and budgets is sidelined. So the very purpose, which is the most important role, is to examine and decide on the policies. But obviously, when you do not really have a freedom of choice in the matter of voting, then definitely your very biggest purpose of examination and the decision taking on the policy is completely sidelined, and the only thing that persists is that any vote that supports or opposes. So the only thing that is seen is that whom are you supporting or who are you opposing. Then further it says that it induces further instability, because obviously the very recent example of Puducherry, Karnataka, and also other states. Now here you can see it gives the example. However, we have seen many of the defectors in such states as the Karnataka and Madhya Pradesh, where they were being re-elected by the bypolls, which were held to their due to their disqualification. So the very purpose that firstly they were disqualified, and due to their disqualification, the government stability fell down, and bypolls had to take place. That means the elections had to take place even before the completion of the tenure of that particular government, and they were again re-elected in those bypolls. So what is the very purpose? How does anti-defection law make sure that these people who are defecting their party or who are responsible for such instability are being punished in any way? So definitely there is no punishment at all. And then finally, it says that the onus is on parties. Now, it says that the problem arises from the attempt to find a legal solution to what is essentially a political problem. Now, what are we trying to do? This is a complete political problem. The people, the MLAs or the MPs, are not staying in their own political party for their political gains or benefits. Maybe they're not able to get a chance of growth in their particular political party, and thus they decide to switch to some other political party. So, wholly and solely, this problem is of political nature. But the cure to this problem, which we are trying to find, is through the legal means, that is, through the 10th schedule or the anti defection law. That is why maybe the right thing to do would be that we put this complete burden and onus on the parties itself, that they make sure that their members are satisfied and they are giving regular, in a way, growth to those members, so that they do not have to switch to the other party in the first place. So all these things, more or less, we have discussed. We'll just go through this once again for a thorough, a cover up. So basically, as we know, that the anti-defection law was included in the Constitution as the 10th schedule in 1985 to combat the evil of political defections. And the main purpose was to preserve the stability of the governments and insulate them from defections of legislators from the treasury benches. Now, what happens is, this was the very problem that, for example, as we know that in our country, in our governmental setup, the majority party, it forms the government, be it at the state, in the states, or at the center. Now, for this majority party rule, we need the number of MLAs in the case of the state legislature and MPs that are member of parliament in the at the center or in the parliament, so that they stick with that particular party, and only then that party would be considered to be standing in majority. Now imagine that, for example, there were 100 members in total, and 51 members, which definitely is a majority because 50% plus one, these were supporting some particular party, say XYZ. Now this XYZ party, since it had the support of the largest number of the members, it formed the government. But now, let's say, for example, 10 members of this particular party move and they vote against this particular party or cause any kind of defection, and thus they join some other political party. Do you think that now still this government has or enjoys the confidence in the Lok Sabha? Definitely not, because here these 51 members, which were earlier there in this party, are no more 51 but just 41 members, because 10 have moved to some other political party. Due to this, a lot of instability was seen in the government, and according to their own whims and fancies, the ministers used, or the members of the parliament or the legislative assembly, they used to move from here and there. So that is why the anti-defection law was brought in the first place. But one thing that we need to notice is that what was the particular scope of this? So this provision was not limited to just the confidence motions or the money bills, which are quasi-confidential confidence motions. Rather, it applies to all kinds of votes that take place in the House on every bill. Now, be it the money bill, financial bill, ordinary bill, or any kind of bill, and every other issue. So this voting is just not confined to the voting on money bills or just for the voting of the confidence motion. Now, as we just discussed, what is the confidence motion? That if at all there is, recently the confidence motion has taken place in Puducherry as well, wherein if there is a doubt that this particular government that is there in a particular state, union territory, or even at the center, if there is a doubt that it does not anymore enjoy the confidence of Lok Sabha, the parliament, so in such a situation, the confidence motion is run through, and it will have to be proved again that how many ministers or how many members of that particular legislature are still in support of that particular government. And thus, this applies to every other issue, and even it applies to the Rajya Sabha and the legislative councils, which have no say in the stability of government, but yet the anti-defection law applies to the members of Rajya Sabha and the LCs as well. Then, an important consequence of the anti-defection law is the hollowing out of our legislature. Now, this is the point that we had completely discussed in the previous slide, that due to this, what happens is that the main focus remains only on whether to whom the vote goes or it does not go, rather than the most important thing, which was that what was the core role of the MP was to examine and decide on the policy bills and budgets. And this is particularly sidelined, and it is completely, not focused upon, and just the only thing that we are paying our attention is to the casting of votes in the houses. So this anti-defection bill weakens the accountability mechanism, because obviously the very purpose of getting the parliamentary form of government instead of the presidential form of government was that we needed a government that is more accountable. So we could really, the constitution framers, they chose to compromise on stability when it came to choosing accountability above it. But still, the anti-defection bill the law has not been able to ensure this accountability to the least. Then it does not even provide stability. Now, the worst case scenario over here is that, of course, even nothing it is being provided by the anti-defection law in the current state, not even the accountability and not even the stability. Because the recent examples of Puducherry, as we know, that firstly, the Lieutenant Governor, who was Ms. Kiran Bedi, she had been brought back and removed by the center as a Lieutenant Governor of Puducherry. And after the new governor had been appointed over there, again, recently, the MLAs over there have resigned. So this has become a new normal over here, that instead of doing any kind of defection or voting against your party, it is even more comfortable to just resign from from your particular party. And whenever the next bypolls or the elections take place, you can definitely take membership of any party and then contest elections. Now, this thing is a very important one. The premise that the anti-defection law is needed to punish legislators who betray the mandate given by the voters also seem to be flawed. Please consider these gaps, they are coming somehow. So here they're saying that the very premise, that the very reason was that it would punish, the anti-defection law would punish such legislators who betray their mandate. That also is flawed. So even that is not happening in the current scenario. So if the voters believe that they have been betrayed by the defectors, like for example, you, I, and each one of us as a voter had elected a particular person and he was a member of a particular political party, and we elected him to that particular constituency whatsoever. So if we think that we have been betrayed by that particular defector, so they can vote them out in the next election. Of course we can. But however, we have seen many of the defectors in the states such as Karnataka and Madhya Pradesh being re-elected by the bypolls, so which were held due to their disqualification. Now, this is the very irony, that the very bypolls that had to be conducted because of these few people, these few members of the legislature, they had betrayed their party and disqualified, and they had defected, they again get voted in these bypolls. So it's just like that. It is a kind of a win-win situation for them, which definitely needs to be brought down. With this, let's discuss the second article for the day, which talks about inhibiting free speech. So this article says that this is basically in the context of that recently the Delhi Assembly has summoned the Facebook honcho Ajit Mohan to depose before the Peace and Harmony Committee. It unwittingly provoked a litigation that may have far-reaching implications on federalism. So basically what has happened is that this Peace and Harmony Committee of the Delhi Assembly has actually summoned a person to give some kind of a statement or produce any kinds of documents. So this particular thing has been questioned, that whether or not it being a legislature, now see, be it the Delhi Assembly, be it the legislative assembly of any particular state, or even if be it the parliament, that is the question which we need to see, that whether or not do they have any kind of quasi-judicial powers or not, because these are completely the legislative bodies. So here, this article says that the parliamentary privileges, this reads out from here. So I will be, I'll try to make you understand it from these points, which are already listed in this article. So that would, we hope that would make your reading of this article even easier. So the parliamentary privileges are a set of rights and immunities that are essential for the functioning of the parliament. Now, as we know that under Articles 105 and 194 of the Indian Constitution, the parliament and the state legislatures are provided some parliamentary privileges. Basically, the members are provided these parliamentary privileges. So the right to free speech in the House, which is one of the parliamentary privilege, guaranteed to the Commons. Now, Commons are the House of Commons, which is in the British Parliament since 1689, and the right to call for evidence and witnesses are central to the role of legislature. See, if at all there is a person who is a member of a particular legislature, and if there is any kind of a debate or argument going on in that particular house, and that member of the house does not even enjoy the basic freedom of speech and expression, can we expect that a good law can be easily framed out? Definitely not. So that is why it is really important that we give right to free speech in that to that particular person, and also the right to call for evidence and witnesses are also important and are pivotal to the role of the legislature, because this will give them an all encompassing power to look at various dimensions of that particular law which they are talking about, and thus a more wholesome law will be there that we might have in the hand. So here are some instances and reasons there that have been given that stand in support of the right of the House to call for evidence and witnesses, just like the Delhi Assembly has done. Firstly, the legislation is not the only goal of discussions. So one thing that we need to keep in mind, that though these are the houses of legislature, but still legislation is not the only goal. Yes, it might be their primary goal, but that's not the only goal. Legislatures also have a separate non-judicial power of inquiry, which has been judicially regarded as being inherent to the legislature. So this is the very first and basic point, that they have a separate non-judicial power of inquiry. So yes, it cannot be exactly in the nature of like the courts of law have the judicial power, though it is a non-judicial power, but yes, they have the power of inquiry, which has been judicially regarded as being inherent and something that is innate to the legislature. Secondly, the legislative lists frequently overlap, and courts resolve any conflict by adopting a test of pith and substance of the law in question. So many a times we know that the subjects between the state list as well, and even in the subject among the state list, and even between the central or the union and the state list also, they overlap many a times, and thus for such instances also the courts also apply the doctrine of pith and substance, that they try to understand that what was the basic substance behind that particular law and how much does it hold merit in accordance with that. So that also is done many a times, and thus it is a regular practice that is taken up several times. Thirdly, we live in the era of cooperative federalism. So this another is a very important point, that it is not the concept of competitive federalism that we follow. Rather, we support the idea of cooperative federalism. That is, that the union and the states must cooperate with each other to form a strong federal structure. And fourthly, there is the delicate use of whether the courts can or ought to sit in judgment on the proceedings of state assemblies, determining what can or cannot be discussed based on the court's view of the topic. Now, this another is one of the privileges of the parliament as well as the state legislatures, that the court cannot outrightly intervene in every kind of proceeding that is going on in the house, and rather it is perhaps only in the rarest of the rare cases that it moves towards the court, and thus it is ideal and it is important that such kind of other powers of non-judicial powers like that of inquiry and other kinds of calling the evidence and witnesses is granted to the legislatures as well for smoother functioning. With this, let's discuss the third article for the day, which talks about the new social media code. So the government on Thursday released guidelines that aim to regulate social media, digital news media, and the over-the-top, which is the OTT content providers. Now, what are these OTT content providers? Like we have the Netflix, we have Alt Balaji, we have Amazon Prime, Hotstar, Disney Hotstar, and like we have various OTT platforms. So the recent problem that has been seen here is that since due to the COVID-19 pandemic, there was a complete lockdown that took place, and thus the cinema halls were not functional. And even before them as well, these OTT platforms were functioning very efficiently. But in this scenario, what has happened is that, like for our Bollywood movies or other kinds of content that goes in the cinema halls, we have the censor board. So that actually takes care that nothing, inappropriate, nothing inappropriate is going on, and thus there is also an age bar. Like there are movies that are 18, that are rated 18 plus, that are rated 12 plus, that are rated, such adult, so UA movies. So all kinds of certifications are given to the movies. But that was completely missing out when we talked about these OTT content providers like Netflix and Amazon Prime, etc. That is why this alarming situation had been raised since a lot of time now, that the children who are not supposed to watch a lot, various kinds of contents on the on such platforms, still they are subjected, and thus this kind of absurd platform or absurd content is available for the young children as well, which can be detrimental for their growth and mental well-being. And thus it was considered that the government should come up with some guidelines or rules to regulate these OTT platforms. So here, this, as you know, that this is the background of this. So the Law and IT Minister Ravi Shankar Prasad cited a 2018 Supreme Court observation and 2019 Supreme Court order in addition to the discussion in Rajya Sabha, once in 2018 and then through a report laid by the committee in 2020. Thus, we can say that a lot of, since about more than 2 years, this discussion was going on, that we need to have some control on the OTT platform and the content they are, the kind of content they are providing. Now, here are the key proposals that the guidelines make for the social media. So the first thing is being a safe harbor to intermediaries that host the user-generated content, which exempts them from liability for the action of users under Section 79 of the IT Act 2000. So here, they are saying to prescribe a grievance redressal mechanism. So if at all some viewer, anybody has a grievance against any kind of OTT platform, so we should have a grievance redressal mechanism platform. So the platforms will need to appoint a grievance officer to deal with such complaints, who might acknowledge the complaint within 24 hours and resolve it within 15 days of receipt. So the first demand or the first proposal that had been brought in this direction was to have a grievance officer that would be appointed by every such platform, and he must acknowledge the complaint within 24 hours and must resolve it within 15 days of receiving that complaint. Now, here are the rules for removal of content from social media. So basically, if at all there is any particular kind of content which is considered to be not appropriate for the viewership, so then that content must be removed. And how it would be removed? The social media platform should not host the content that threatens the unity, integrity, defense, security, and sovereignty of India, friendly relations with foreign states, or public order, or causes incitement to the commission of any cognizable offense, or prevents investigation of any offense, or is insulting of any foreign states. So basically, if any of these things are doing there is a potential of any such thing happening by that particular content, or that content is defamatory, it is obscene in nature, pornographic, pedophilic. I hope you understand the meaning of these words as well. By pornographic, we mean anything that is to do with the kind of the pornographic or the sexual content which is not appropriate for various age groups. Then pedophilic content is the content, like for example, pedophile is a person who is an adult, who is a mature person, and he has a kind of this bizarre to what the exact word what should I be using is, that he has this particular sexual desire towards the children. So for example, if there is a person who is aged 45 or 50 years old and he still has some sexual interest in a child who is just, say, let's 10 or 12 years old, so that person would be pedophilic in his nature. Then, if that content is invasive of another's privacy, that it is including bodily privacy, insulting or harassing on the basis of gender, libelous, which means any kind of libel or slanderous or defamatory, racially or ethnically objectionable. Now, recently, I'm sure you must have heard of the controversy that is going on regarding to that the web series called as Tandav, which is, if I'm not wrong, it's on Amazon Prime, I guess. So that also it was set to hurting the sentiments of the Hindu religion. So such things are, if they are at all objectionable, then these, or they're relating to encouraging money laundering, gambling, or otherwise inconsistent with or contrary to the laws of India, etc. So if there is any kind of content, then that should be removed. So if on receipt of the information from the court or government, this content should be removed within 36 hours. Then the penalties for the companies for violating these guidelines. So what are the penalties? So in case of intermediary fails to observe the rules, it would lose the safe harbor and will be liable for punishment under any law for the time being in force, including the provisions of the IT Act and the Indian Penal Code. Also, the companies can be liable under Section 66, 67A, and 69 of the IT Act 2000. So here are a few current laws which we currently have in India that actually can cover such problems with the IT or with this OTT sector. So firstly, no specific, but this also we should keep in mind that there is no specific provision under the IT Act that defines privacy or any penal provisions relating to privacy, but there are some sections of the Act which deal with it. Firstly, we have section 43A, which talks about the compensation for failure to protect the data. Section 72, penalty for breach of confidentiality and privacy, and 72A, which talks about the punishment for disclosure of information in breach of lawful contract. So these are the provisions, but yes, obviously it is way better that we have currently the exact guidelines which aim particularly at controlling these OTT platforms in a positive manner. With this, let's see what do we have for news and flash today. INCOIS, which is the Indian National Center for Ocean Information Services, is set to do aerial mapping of the ocean floor. Now, what is important for us is that what is this particular technology or method called? This is called as the bathymetric study. So the INCOIS is planning to take help of the National Remote Sensing Center for the aerial mapping. That means with the helps of drones or other devices, the aerial mapping of the Andaman and Nicobar Islands and Lakshadweep will be done for the better picturing of the ocean floor using the bathymetric study. So what is the bathymetric study? It is the aerial mapping of the ocean floor done with the help of drones or other possible gadgets. Secondly, ancient Buddhist monastery found in Jharkhand. So this is the recent excavation that has taken place. So the Archaeological Survey of India has unearthed a Buddhist monastery believed to be about 900 years old in Hazaribagh district of Jharkhand. So this presence of deity Tara, the name of that deity is Tara, shows the possible proliferation or presence of the Vajrayana form of Buddhism in this region. The Vajrayana form of Buddhism was basically more closely related to the Hinduism or the Hindu culture, wherein this was a kind of a more tantric version of the Buddhism that existed. And thirdly, Malayalam poet Vishnu Narayanan Namboothiri passed away. So he was noted for the depth of his scholarship in the literature and philosophy of India and the West. Vishnu Narayanan Namboothiri was highly respected as a teacher and orator, and he represented the finest traditions of contemporary Malayalam poetry. So this needs to be kept in mind that he was a Malayali or a Malayalam poet. So this was all for the day. We hope it was a good session for you. Please stay tuned with Lawseco for such more sessions to come. If in case you wish to download the PDF of today's slides, you can join our Telegram group, the link to which is there in the description box below. Thank you so much.